Hello everyone. This is Dharani from Origin IP Solutions LLP Bangalore. We are one of the leading IP firms in India. We bring out IP videos once every fortnight with an intention of sensitizing the public about innovation and IP. Today, we will be focusing on 5 steps that inventors need to consider before filing for a patent. If you like this video, don't forget to subscribe and hit the bell icon below to receive updates every time we bring out a new video. This video is beneficial for inventors from different entities, be it scientists or engineers working in research and development departments of various organizations, or even faculty, research scholars, and students belonging to academic institutions. This video is basically designed to give any inventor a few pointers on the steps that are required to be considered before filing for a patent. Among the 5 steps that inventors need to consider before filing for a patent, step 1 is to perform an IP audit. I'm sure many of you listening to this video are not familiar with this kind of activity. I will just briefly explain it to you so that you get familiar with the terminology. Let us start by asking the basic question, what is an IP audit? Many resources define IP audit as a systematic and comprehensive review of the IP owned, used, or acquired by a business with an objective to identify the registered or non-registered IPs in the company. So, in simple terms, it is a process of taking a look at the IPs owned by a company and make a list of the IPs that are registered or protected and those that are not registered. The next question we may ask is, what is the outcome of an IP audit? Well, the outcome of an IP audit is to provide an IP roadmap for a particular entity which highlights the recommendations provided for the registration of new IP or maintenance of previously registered IP. Since the level of fairness regarding this IP audit is low, Origin IP Solutions has taken an initiative of providing complimentary IP audits for companies or institutions wherein Origin personnel will be visiting your organization, taking a look at the IPs owned by you, and providing you a roadmap on the steps to be taken subsequently from an IP perspective. The next important step for an innovation-driven entity is to have a standardized invention disclosure form, or IDF as we call it, for all the employees of the organization. By implementing a standardized invention disclosure form, the company is not only ensuring a streamlined process for proper documentation of the invention, but also creates a culture of innovation for all its employees. I'm sure some of you must be wondering what an invention disclosure document is. It is nothing but a simple template in which all technical details of your invention are mentioned so that the inventor does not miss out any detail while filing for a patent. The important parts of an IDF are a background section to highlight the disadvantages of the existing systems, a description of the invention which involves all the components which may be used in the invention as well as the working principle. The written description may be supported with a few diagrams of the product or process for easy understanding and representation. The IDF can be concluded with some key advantages of your invention as to how it is capable of bringing out a change in the market. The next step is one of the most critical steps among the 5 steps that we are going to discuss today. So inventors are advised to perform a due diligence of their invention under professional guidance. Some of you may be wondering about what a due diligence is. Let me explain it to you now. Due diligence is nothing but performing a patentability search, which is advised before proceeding with patent filing. Through a patentability search, an inventor will get to know if there are other inventions around the world which might be similar to his invention. With this knowledge, the inventor can take up some action on improving the features of his invention for a better chance of obtaining a patent. The patentability of an invention is assessed using three basic criteria. The first one is novelty. Novelty means new. The search checks if an invention is new or not, and an opinion is provided to the inventor regarding the novelty of his invention. The second criteria for patentability of an invention is non-obviousness or inventive step. Even though an invention qualifies a novelty search, it is very important for the invention to be non-obvious for the people skilled in the art. Further, the invention is required to have an inventive step in comparison to its prior arts for improving its chances on obtaining a patent. The third most important criteria for patentability is the industrial applicability of an invention. In addition to being novel and non-obvious, an invention must have industrial applicability to be eligible for obtaining a patent. If an invention is novel and non-obvious but does not qualify or have any industrial usage, it will not be qualified for a patent grant. We have listed out a few free and paid databases one can use for performing a patent search. You may make a note of it for your reference. Among these free databases, Google Patents is a common favorite among professionals due to its easy usability and accurate results. Many of you might be under the impression that anything under the sky can be patented, but unfortunately, that is not the truth. Section 3 and 4 of the Indian Patents Act 1970 lists a few categories of inventions that is considered to be non-patentable subject matter. The purpose of Section 3 and Section 4 of the Indian Patents Act is to discourage and prevent monopoly over inventions which are injurious to health, environment, morality, national defense and security. The Patent Office grants patents only for the inventions which are useful for the society and progress of science and technology. Let me briefly take you through a few of them. Now I'll just be taking some examples of the subsections of Section 3 and Section 4. So let's start with a few examples. Patents are not granted for inventions that are considered to be frivolous as they might be against well-established natural laws. For example, a machine proving the famous law of gravitation to be false is not patentable as law of gravitation is a well-established natural law. Patents are not granted for inventions against public order or morality. For example, a method of committing suicide is not patentable. Similarly, a product to create destruction is also not patentable. Other methods of enhancing environmental pollution are also not patentable. Patent is also not granted for inventions involving discovery of a scientific principle. For example, you cannot create a product which involves Newton's laws of motion or Archimedes' principle and claim that you have discovered it. Patents are also not granted for inventions pertaining to the discovery of a new form of a substance which does not result in the enhancement of a known efficacy of that substance. For example, chlorobenzene and fluorobenzene are two derivatives of the famous compound benzene. Till these two compounds exhibit individual capabilities, they are still considered as benzene, which is their parent compound. Section 3D is very important and has been very controversial in the Indian Patents Act 1970. Patents are also not granted for inventions relating to a method of treatment like a method of performing a surgery. However, you can patent a product which is used for performing a surgery, whereas the method of performing the surgery may not be patented. Section 4 mainly talks about inventions relating to atomic energy which do not qualify for a patent for the purpose of national defense and security. Before we move on to the last step, I would like you all to answer this question to yourself. If you are an inventor, which stage of the invention are you in? Is it the idea stage? Or are you in the development stage? Or Are you in a stage where you have a prototype of your invention? So the answer for this question basically determines what your next steps would be. I hope that all of you have diligently answered this question, as it is the most critical decision to make in order to proceed further. It is important to make the right choice now, as you may lose money or time in case a right decision is not made due to lack of clarity. There are two kinds of applications: provisional application and non provisional application. Basically, non provisional application is the terminology that is used in the US, and in India, we call it as a complete application. So, let's take up provisional application first. The provisional application is filed when you are at a very initial stage of the invention, which may be an idea stage or even during the development stage, as there is scope for further changes in the invention. A provisional application is filed just to ensure that you obtain an earlier date of priority, such that you will be able to claim rights over the invention if inventors file similar patents after you. Basically, a provisional application is like a reservation for your invention and gives you a legal edge over other similar inventions which may be filed after you. The next kind of application is the complete application. It is basically a final application that must be filed once the invention has been completed and a prototype may have been developed. Once a complete application is filed, no changes can be made to the application, due to which the inventors must be very careful before filing a complete application. Please note that provisional application will not be examined by the patent office. Only the complete application will be examined by the patent office, after which it will be prosecuted before a patent grant. I recommend inventors to consult a patent professional before taking this critical decision. We are now in the last leg of this video, and I would like to close off with a few pointers for your benefit. The first one is, always remember that even if you decide to file for a provisional application, it can be converted to a complete application within 12 months of the initial date of filing. Inventors are always recommended to file for a patent in their home country first before considering an international filing. International filing may be divided into PCT filing and convention filing. Under PCT filing, there are about 150 countries that are covered under PCT filing. So inventors who are not sure about the countries that they want to file in can proceed with PCT filing. They'll be getting about 18 months of time before they can make a decision as to which are the specific countries that they would like to file. On the other hand, if the inventors are sure about the countries in which they'd like to file for a patent, then they can directly go into filing for a convention application, which is basically a direct application that enables inventors to file for an application directly at the countries of their interest. As inventors, the most important step that you will have to execute is to assess the business relevance of your invention before you proceed or think about patent filing, basically. Even if your invention satisfies all the criteria of patentability, but it does not earn you a place in the market, then there is no point in spending so much time and money for the patent process. We recommend that you must understand the commercial outcome of your invention before investing time and money for the patent protection. So that's all from my side today. I hope you all have some valuable takeaways from this video. In case of any IP support in terms of patent filing, trademark, contracts, design registrations, please send us an email to info@origin.com. We also have another sister concern company called Origin IP Academy, which is more about IP education. We have several ongoing online courses in IP, which can be taken up by you at the convenience of your home. We are also conducting a conference on technology transfer and commercialization in collaboration with Vellore Institute of Technology between 19th to 21st of September 2019. If you're interested to be a part of this conference, please do write to us at info@originipa.com. So this is ORIGIN, originipa.com, for further details. In case you have specific requirements with reference to the topics to be discussed in our videos, you can feel free to write to us with your suggestions, and we will surely honor them in the near future. Thank you all.